Hi, this is David Cox, immigration attorney in St. Louis, Missouri. We're here at Blondie's off of Washington Street in downtown St. Louis, here to answer your questions with lunch with a lawyer. So the Obama administration had about 18 months ago promised to pass regulations in expanding what is a currently available solution for someone who's been in this country and overstayed their status. For example, they may have come as a tourist and stayed and didn't go home when they were supposed to, or they may have come into this country illegally without ever being inspected. These people are considered to have accrued unlawful presence. That makes them inadmissible to this country. So even if they're married to a U.S. citizen or have U.S. citizen children, they cannot easily regularize their status. This new regulation that the Obama administration has been working on for so long and was finalized this month allows people in that situation to apply for the benefit here in the United States without leaving the country. The way this works is if somebody in that situation who has accrued unlawful presence leaves the United States, the way the law is currently written, they are barred from returning for 3 or 10 years, depending on how long they overstayed their welcome. And this creates a problem because the current law only allows you to apply for relief based on your marriage to a U.S. citizen or having U.S. citizen children at a consulate overseas. So you would have to go to the consulate overseas, apply for this relief, and wait outside the country for what could be years for a decision on your request to enter the country having that unlawful presence bar waived. This regulation allows you to apply for that benefit while you're here with your family in the United States. What is issued is called a provisional waiver. It's basically saying, assuming everything pans out and there aren't any problems when you do go to the consulate, you're already approved before you leave the country for this waiver of unlawful presence. So it's going to help families stay together longer, but it really doesn't change much as far as the logistics of qualifying for the relief, just how you apply for it. And that's a big deal, though, because a lot of people have not applied for it knowing they might be separated from their families for years if they try. So this is a big development. You cannot file until March 4th, but if you have a I-130 approved, which is a petition for an alien relative, you can be prepared to file after March 4th. If you haven't and you qualify, you could file a petition now. They're only available to immediate relatives. In other words, you have to have, if you're a foreigner and you want to apply for this waiver, you have to be married to a U.S. citizen spouse or have U.S. citizen children, or you could be the parents of U.S. citizen children, for example. So only those categories of people initially qualify, and in addition to that, this unlawful presence has to be the only thing preventing you from regularizing your status. If you have a criminal history, or if you have a communicable disease, or something else is keeping you from immigrating to this country legally, this waiver won't help. At least this way of applying for the waiver won't help. You would still have to use the previous method of actually leaving the country and risk that separation to apply for the waiver at the consulate. This has been Lunch with a Lawyer. I'm David Cox, immigration attorney in St. Louis, Missouri. Visit our website for more information like this on a regular basis.